Good morning, ladies and gentlemen of the court. My name is Julia Adinolfi, and I am here as an attorney representing James Madison. We are here today to argue that not only is my client well within his rights to not deliver a commission to William Marbury on behalf of former President Adams, but that a writ of mandamus that could possibly force him to do so is in itself unconstitutional. The facts of the case are as follows. Former President John Adams signed the Judiciary Act of 1801 into law just before he left office to ensure that his Federalist agenda would still be pushed through via his 16 newly appointed judges. However, this plan was not very well thought out because his Secretary of State failed to deliver all of the commissions by the time the clock struck 12 on the last night of Adams' presidency. The remaining undelivered commissions awaited President Jefferson when he took office that morning. Given that these commissions were from a former presidency, President Jefferson rightfully considered them invalid because a commission to become an appointed judge is not official unless delivered to the recipient. President Jefferson ordered my client, Secretary of State James Madison, not to deliver them. William Marbury, a man whose commission was never delivered, would like you to issue a writ of mandamus to force my client to deliver the voided commissions. Not only does Marbury have no claim to a commission that was neither delivered nor officiated by the end of the former president's term, but the actual writ of mandamus would be unconstitutional itself. The action of a writ of mandamus in this case is derived from Section 13 of the Judiciary Act of 1789, which expands the power of the judicial branch past what is explicitly stated in the United States Constitution. The Supreme Court does have the power to issue a writ of mandamus in a case that is in their original jurisdiction, and cases not in that original jurisdiction must first go through appellate court. In Article 3, Section 2, Clause 2 of the United States Constitution, it says that a case may be within Supreme Court original jurisdiction only if it involves the following: ambassadors, other public ministers and consul, in cases in which a state is a party. In this case, there are none of the above, so according to the United States Constitution, this case should not have been in the Supreme Court original jurisdiction in the first place, and we should be standing in front of an appellate court right now, thus nullifying the court's ability to order a writ of mandamus. However, William Marbury would rather the court follow the Judiciary Act of 1789, which states that the Supreme Court can issue a writ of mandamus to anyone holding office, meaning Secretary of State, my client James Madison, rather than only to the parties explicitly stated in the Constitution's description of an original jurisdiction case. This is a case of first impression, and is giving the Supreme Court the opportunity to review the constitutionality, or lack thereof, of the Judiciary Act of 1789. The United States Constitution is the supreme law of the land in this country, and any other laws that conflicts with or threatens to challenge it should be struck down. We ask you to look at this case through two lenses. First, we ask you to look at the plain and simple text of Article 3, Section 2, Clause 2 of the United States Constitution, and recognize how it clearly states the indisputable conditions of an original jurisdiction case, none of which are seen here today. Secondly, we ask you to look at the structuralism and functionalism of the Supreme Court and judicial branch as a whole. You have a duty to review the legality and adherence to constitutional law of any other laws from other branches of government, such as, but not limited to, the Judiciary Act of 1789. And you must ensure that no single branch, even the judicial itself, has unwielding power. In conclusion, in this case of Marbury v. Madison, we ask that the court withhold from issuing a writ of mandamus that in itself challenges the principles of original jurisdiction seen in Article 3 of the United States Constitution, and which would force my client, James Madison, to deliver commissions that were clearly voided when they failed to be delivered during the previous presidency. Thank you.